Welcome to our Rapid Fire Wednesday Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in San Diego, and I am joined by Miki Matrician, the co-managing partner of our Boston office. Hey to you, Miki. Hope all is well.
Hi, Kim.
All right, so this past week has been another whirlwind of new developments from the Trump administration. So today we will be rapid firing again as we touch on each of these announcements that impact employers and employees. So these announcements also will have an impact on immigration strategies that are being enlisted or will be enlisted by global mobility and HR professionals. So what are we going to discuss today? Well, we're going to discuss the interim final rule on the new registration requirement that became available on Friday, March 7th, but is not yet published in the Federal Register. We're also going to talk about the new forms that were issued on March 3rd and 4th that were made effective immediately without any notice period or grace period by the Immigration Service. And finally, we'll discuss a USCIS memo issued on February 28th regarding notices to appear that are being issued upon denial of an application. All right, so Miki, let's start out with the interim final rule on the new registration requirement. Can you tell us about this new development?
Yep. So the unpublished version of the IFR on the registration requirement became available on Friday, March 7th, and it's due to be published on Wednesday, March 12th. We discussed on last week's Rapid Fire Wednesday that USCIS had just announced the registration requirement based on the January 20th executive order protecting the American people against invasion. And when we were discussing it last week, we just knew that there would be a new process that would require individuals to create a USCIS online account that would be used to completed by non-citizens that are staying in the US for 30 days or longer. And we also knew that non-US citizens would need to be fingerprinted and registered unless they've already been registered through an existing immigration process. And those non-US citizens include permanent residents, I-94 recipients, individuals in removal proceedings, and EAD holders. And some individuals that may not already be registered included undocumented individuals, certain Canadian visitors, and some DACA and TPS holders. So what we didn't know was how it would all work out and what penalties would be imposed if a foreign national didn't comply. And now we know that the rule would go into effect 30 days after publication of the regulation. So that would bring us to Friday, April 11th. And we also know that the process would involve foreign nationals creating their own MyUSCIS accounts for themselves and children over the age of 14 and submit forms G325R. And that submission would then trigger the issuance of a biometrics notice for a designated application support center location that they would need to report to at a specific date and time. And the completion of the biometrics would then generate a registration receipt that would then be uploaded to the MyUSCIS account, which then foreign nationals would need to print and carry. Also, any change to the residential address has to be submitted within 10 days of the address change. That's been an existing process and rule. And we also now know what the consequences would be if foreign nationals don't follow this process. It would be essentially a fine of up to $5,000 and imprisonment of up to 6 months for willful failure to register. As for failure to carry the registration receipt and failure to report address change within 10 days could result in a fine of up to $5,000 and imprisonment of up to 30 days. So pretty serious consequences there. Most foreign national workers have I-94s, and so they wouldn't need to register under the system. People who previously registered also wouldn't need to be re-registered again, even if their I-94s expire. However, the reason that we're focusing on this on our Rapid Fire Wednesday is because this rule impacts foreign national children. So dependent children who turn 14 years of age would need to register within 30 days of turning 14. So parents really need to be on top of this requirement. And global mobility and HR professionals may want to help communicate this requirement to foreign national employees.
Yeah, that's really helpful information, Miki. So it does, remains to be seen how the resources being allocated to enforcement of this provision are going to impact the adjudication of benefit applications at the U.S. Citizenship and Immigration Services. So wait and see on that. But another new development from last week was that on Monday and Tuesday of last week, USCIS published 12 updated forms that were effective immediately without any grace period. Those included forms such as the I-45 application to adjust status to U.S. permanent resident, the I-45 supplement J, as well as the forms I-131 for travel documents and N-400, which is the naturalization application. So the point of this was to remove gender identity questions from all forms and to revert to referring to citizens as aliens, right? So now we're going to go back to calling people aliens. And then there's only two genders, male or female. So effective immediately meant that any applications that were ready to be placed in the mail that day were no longer valid and needed to be redone on the new version of the form, which was actually dated January 20th of 2025. So it made it look like the form had been out for a while, but that's the date of the executive order, and that's what they listed on the form. So requirement of the new form versions without any grace period meant that people who filed applications on the wrong version, which essentially was the correct version as of earlier that day, would have their applications rejected, and they may have fallen out of status in the interim by this improper rejection. So our bar association, the American Immigration Lawyers Association, which we refer to as AILA, was meeting with members of Congress to ask them to exercise oversight over USCIS and to ask USCIS to announce a grace period of at least 1 month and post public guidance about this grace period. AILA then filed a lawsuit on Friday, March 7th, when there was no action. And then on Saturday, March 8th, USCIS updated its forms website, indicating a grace period through April 2nd for the old versions of the forms. So only the new version will be accepted as of April 3rd, but there is now that grace period that would have been nice to have had before. So there was a lot of angst going on with that whole situation.
Yeah, that was quite a whirlwind, but I'm definitely glad there's now a grace period, even if it's just a month. So, the final topic for today is the USCIS memo on notices to appear. Kim, do you want to tell us what that memo is all about?
Yeah. So removal proceedings are initiated via a document that's called a notice to appear, which is a charging document that starts the court proceedings. So this USCIS memo states that it will initiate removal proceedings after it denies an application if, as a result of the denial, the foreign national is no longer authorized to be in the United States. So the policy does specifically exempt beneficiaries of employment-based petitions. However, we are discussing this memo because it does not provide an exemption for dependent family members. So while it can exempt the H-1B petition beneficiary, which would be the employee, the dependent family's H-4 applications, if those are denied, removal proceedings would not impact the H-1B worker. But as the memo is written, proceedings could start for that particular worker's spouse and or children that had an application that was denied. So this memo is effective immediately. And as such, we're going to stay tuned on the progress and provide an update here if USCIS later clarifies an exemption for dependent family members of employment-based petitions. So one other thing to note is that beneficiaries of family-based petitions that are denied would in fact be impacted. And what this means is that for people who are in non-immigrant status and filing I-130 petitions and I-45 applications, or an I-45 pursuant to an I-140 immigrant worker petition, you should consider having their employer support to maintain their work-based non-immigrant status wherever possible. Right, Mickey, we always advocate, like, keep your non-immigrant status if at all possible, and now even more so with these NTAs that could come down the pike soon.
Absolutely agreed.
All right. Well, those are the 3 updates we have for today. Again, a lot has been going on in the immigration world. And so as we wrap up today's session, we invite you to stay tuned for future episodes on updates to the immigration landscape. And if you don't already, please follow us on our LinkedIn page for WR Immigration, as well as our individual profiles. And we also transcribe this Rapid Fire Wednesday and post it to a weekly newsletter that you can subscribe to. So until next week, great to see you, Miki, and we'll keep you updated.
Great to see you, Kim.